5 seconds to go. Start. Such circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability the crime was committed by the accused and none else. Further, the facts so proved should unerringly point towards the guilt of the accused. The circumstantial evidence, in order to sustain conviction, must be complete and incapable of explanation of any other hypothesis than that of the guilt of the accused, and such evidence should not only be consistent with the guilt of the accused but should be inconsistent with his innocence. These were so stated in Sarda Supra, where the court, after quoting from Hanumant, observed that a close analysis of this decision would show that the following conditions must be fulfilled before a case against an accused can be said to be fully established. The circumstances from which the conclusion of guilt is to be drawn should be fully established. It may be noted here that this court indicated that the circumstances concerned must or should and not may be established. There is not only a grammatical but a legal distinction between may be proved and must be or should be proved, as was held by this court in Shivaji vs. State of Maharashtra 1973 to SCC 793, where the following observations were made. Certainly, it is a primary principle that the accused must be and not merely may be guilty before a court can convict, and the mental distance between may be and must be is long and divides vague conjectures from sure conclusions. The facts so established should be consistent only with the hypothesis of the guilt of the accused, that is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved, and there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. These 5 golden principles, if we may say so, constitute the punch seal of the proof of a case based on circumstantial evidence. These punch seal precepts, so as to say, are now fundamental rules iterated time and again, and require adherence not only for their precedential weight but as the only safe basis upon which conviction in circumstantial evidence cases can soundly rest. This court is of the opinion that given the testimonies of 2 sets of witnesses, PWs 2 and 3 and PW 4 and 5, who deposed to seeing the accused with Hushan Jahan and the first 2 accused on 8th October 1999 and 9th October 1999 respectively, and also given the serious flaws in their testimonies with respect to the knowledge of PW1, the flaws in their testimonies regarding their presence at the place and time deposed to by them, as well as other glaring inconsistencies, the prosecution cannot be said to have proved its case. If benefit were to be given to PW1's statement and he were to be believed that the police did not take any action till he applied under section 156(3) his conduct in not stating anything during inquest proceedings, despite being informed about the facts by PW2, PW3 and PW4 that about seeing the boy in the company of A3 Hushan Jahan on 8th October 1999 and later on the early morning of 9th October 1999 undermines the prosecution story. Likewise, if the prosecution version that there was a previous enmity or grudge on the part of the accused which constituted a motive to kill the child is correct, the conduct of PW4 and PW5 in not taking any steps to ensure the safety of the child when they saw him in the company of the accused is unnatural. This is more so because PW5 is admittedly related to PW1. As discussed previously, the testimony of PW5 with respect to the circumstances under which he saw the deceased early morning of 9th October 1999 renders it untrustworthy and unbelieved. This court is also of the opinion that apart from the above serious infirmities, there is no evidence, oral or any material object, which connects the appellant accused with the crime. It has been repeatedly emphasized by this court that the last seen doctrine has limited application where the time lag between the time the deceased was seen last with the accused and the time of murder is narrow. Furthermore, the court should not convict an accused only on the basis of the last seen circumstances. Stop.